Good morning to the students of the SLW600. Karibu sana to my class. Welcome to my class. And today the topic which I am going to deal is, I highlighted on the screen, that is how to find their ratio Decidendi. That is our topic today. And I already sent my handouts to your CR. Perhaps you might have received it. There are a number of the handouts are there because we can take the gist from it and what I taught, that will be the enough for your examination. So now, without wasting the time, let us come to the point of the finding the ratio decidendi of a case has to be one of the trickiest skills to master at the law school. How could you know that this case is very much decided on the rationality? We can easily make it out whether the case is decided on the rationality or not, because every person is having the same mind, so that they could think it, whether the natural justice is followed or not, whether any injustice is followed there or not, we can easily make it out. So this is the trickiest way to know this case is a ratio decidendi. So lecturers explain that the ratio is the rationale for the decision. Rationale for the decision is a ratio. Decidendi means decided thing. A thing which is decided in the rationality is a particular thing which can be used for a permanent basis for the future cases of such a nature will come or appear, then it can be a model, and a court will not decide again because the matter is already decided. So, but when you are at home trying to write a case note, it can feel like a ratio decidendi is really Latin for a good luck with that. See, case briefing is concerned, case note is concerned. I don't know whether you studied in the legal method, the outlining the case, briefing the case, and following the PFIRAC model and following the Iraq model. And these are the things you have learnt in your legal methods. How you can write a decided case by using the PFIRAC model. That means P means PFIRAC, parties. F means facts. I means issue. R means rules. And C means conclusion. That is PFIRAC model for the decided cases. For problem cases, we write in Iraq model, IRAC. The Iraq model is I is issues, R is rules, and A is application or analysis, or C is conclusions. PFIRAC model or Iraq model. Either you can say A as an analysis or A as an application also. Have you gone through in your legal method first year? Say yes or no. Online. Say yes or no. Sir, we don't know because we did not hear your question. Okay, let us come to the point. Here are some of the tips for the tracking down the elusive ratio. How can make it is a rational ratio? I told you, justice is different, rationality is different. And the best example I have given is cyclist and motorist. And the motorist stationary, his car is stationary, means stand still. But the cyclist came and collided with a stationary car. What is the stationary spelling? Anyone, online or offline? Stationary spelling, a stationary car. Spelling? Say, I don't know. What about you? Stationary. Two meanings are there. If you write with the ARY, means STATION, ARY means that is stand still, without movement. But if you write STATIONERY, that means pen and pencil, rubber, that stationary shop. So here stationary means stand still, NARY. The cyclist collided with the motorist, and a person saw it, and the 100% mistake of a cyclist. Now you say, tell me, if you go for the justice is concerned, the motorist will not supposed to pay anything. But people will say that the cyclist doesn't have the money, and that rationality they use it. They don't use the justice. The rationality they use it. See, that is a mistake, no, but anyway, that so and so thing. And the poor fellow motorist has to pay at least something to that fellow to make the bend repair, the rim, rim repair. Now you tell them what is the rationality, what is the justice here. If you see the justice, it is 100% fault of a cyclist. But the rationality says a person's, that fellow is a poor fellow and he cannot have that much money to repair it. Better you pay some 5,000, 2,000. Okay, you pay the 2,000, 3,000, he will make a repair. So rationality is different and justice is different. And the legality is different. So rationality, they say, because rationality they will count it because he doesn't have the money. Irrationality. If you strictly speaking also, for 500, 5,000, 10,000 is not a big amount for the motorist. Am I right? So, number one, look at your subject outline, a reading list or case list. How to take a peek at the top topic headings, case, journal articles listed above and below, the case you are able to read. And during this, before you start reading the case, will help to provide some context for your research for the ratio and help you to avoid getting sidetracked by all other obiters. When you read the decision, in the beginning you could not know what is the rationality. After reading, you can get an idea that perhaps it should be decided in this manner. Because you have your own idea would be there, rationality you apply there. And by reading it also they can say, yes, there is a rationality is there. And yes, this case is worth reading. And you apply it. The judgment given in by following the proper interpretation or not. That is the very, like biting with the teeth. It will not come out of the stab. But rationality is not there. A people can use their hand and they will kill the people. Because they know the nodal points. Where to kick him, that fellow will die. So they will make kick it in there, the fellow will die. But he say he doesn't use the instrument. He doesn't use the stab or wound. Not necessarily. Hands are his instruments. So rationality is there. Biting the nose, case law, and that poor woman, they are not going to get anything. But rationality is not there because they interpreted stabbing or wound with the instrument. But teeth definition will not come over there. It is an absurd. In the same way, greasing. Greasing on the railways, the side track, when they want to make a track, it will touch here. Then the engine will go this side. And if it is touch here, then engine will go this side. If it not straight it will go. So when you want to take the deviation of engine, these railway track changes are there. Even a greasing also a maintenance. But they did not take such a thing. Only packing the sleepers and the railways, they said, remove it. Because your face become like that only. So I don't know whether you're married or not, but diminishing chances of marriage. That's my point. Okay, come to the point again. And here, while you are reading only, you could understand whether the straight track is there or by that obiter dicta, and there is no straight track in the judgments. At that instant, you can say it is a rationality is there. Like another case law that I told you, shops can be closed at least one day in a week. and you don't say that I have not employed the employee, I myself is the owner, I am the employee. Either you are a owner or owner wife or employee, doesn't matter. One day you have to close it. Okay, if the shop and house are only one, you're using the gate, don't sell, keep it. Keep it, no sale today. Caution board you put, even though you are using the shop. If you don't keep the caution board, a man like me will say, why did you open the shop? Because he cannot say the shop and house both are same, and the door is the same. And hence, he will not make the shutter. He will make only one man going way. But he will keep a caution board. No sale today. And that is a must. So, that is also a count rationality is there or not. There is a rationality is there because to protect somebody's health, at least let him have a relax. Go to the movie, go to the beach, or spend with the children, spend with the father, mother, make a picnic, or have a good talk, or have a best pilau, you can pick a pilau. So then we can have the get together, you can speak together, at least you will be relaxed. So that is the main idea behind it, keeping one day leaves. And then the rationality is there. The rationality is there. But production engineering, I already told you, they will give one day leave and one day salary also, if they could work on that day. But everybody will not get such a work. Only compulsory duties people will get such a work. So now let us come to the point. Read the head note. The Chief Justice Gleason once said that there are some cases where people who write head notes deserve a medal. Head note is always a lucrative, a touching, a stylish, and attractive head note when you write it. So even an article, when you are going to write the article, your head note is a bit, a new type, it looks like. Emerging trends in law in the 21st century. See, is it not a modern? Emerging trends of law in 21st century. How the law is changed, how they are making it, or a statute, or any other thing. The impact of the technology in the administration of justice, or in the impact of the innovatory technology in the legal education, and the modern techniques in the legal profession. See, a new type of the thing. So your heading should be very much attractive. That is the thing. There are some cases where the people write head note deserve a medal. They write the head note, heading plus the content of the head note. Heading plus the content of the head note. If you could write it, really it's a, in only 4 words or 5 words, you can give the entire case law. The entire case law you can give in the 5 words. I don't know whether you read the Donoghue versus Stevenson. What is that case law? Yes. What is served there? Kunwanini. Hapana. Kunwagani. Donoghue versus Stevenson. A fancy, he has taken the fancy to the bar, to the pub, and offered her some drink. What is that drink? Ginger beer. That is ginger beer. And he poured in a tumbler and she consumed it. When he poured the next tumbler and he found, Nini, a rotten snail. And by looking the snail, which is dead, putrid, decayed or rotten, and she got the nausea and she vomited. Tapika. And later on she was hospitalized. So the whole story you can give in the only 3 or 4 lines. It is their negligence, number 1. Number 2, product liability, a person who make it. And number 3, worth consuming. Number 4, liable for damages. Headline, head note. It is a purely a negligence on the part of the manufacturing company to produce such a product. When you produce the product, it should be worth enough to consume. So quality control is missing. That is negligence. Product liability is there because there is no intervention of any other new thing. Intervention is not there. Means the sealed bottle. And the bottle is opaque bottle. That's why you could not see what is floating inside. If it's a transparent one, yes, we can see that something is floating inside. And we can give the head note only in the 4 or 5 lines, 4 words only. In that way that you can easily make it out. The head note when you are writing, write the gist of it. When you are writing an article also, you write an abstract. And Chini, you write the keywords. And the keywords are said to be the head notes in one way, in another way. In each case law, there is a head note is there. Head note not goes with the sentences. Hyphen. Only hyphen. Negligence, product liability, negligence, hyphen, product liability, hyphen, and they will write liability, consumer liability, then damages, hyphen. So head note is in that way. So when you write the head note, yes, you write in such a way where the people deserve the medal, and he was right. When you start reading the judgment, begin with the head note. Always head note come first. Begin with the head note, and this will highlight the key issues. I told you, keywords. The key issues are the legal principles considered by the case. What is the legal principles considered by the case is clearly shown in the head note. Online people, are you there? Say yes.
Yes.
I appreciate. Otherwise, I didn't know whether you are there or not. Chakula kula.
Yes.
Keeping it on. So I would like to see that whether you are present or not. Okay. Now the third point is, can you read the third point? Read the whole case, which I am highlighting. Read, keeping the gadget very close to your mouth. Sauti kubwa, amna paka, kama simba. Unmute and read.
The ratio normally appears towards the end of judgment, but unfortunately, you can't just skip to the end. It's a bit like watching a mystery show. It's harder to find the answer when you jump in part way through. So you have to read the case in full.
Yes. Thank you very much. Read the whole case. In the beginning, we cannot understand. Even myself also cannot understand in the beginning whether case is admitted, whether case they won it, whether they get dismissed. They say Chini dismissed. What dismissed? He is the plaintiff and he is the defendant. Suppose this fellow goes to the respondent. Yes, he is the respondent and that fellow is the defendant at the time. So who is he? Then the confusion comes. But when you go on reading it, yes, you will understand. Okay. In the lower court, he is the plaintiff. In the higher court, and he is a defendant, or in generally say, appellant and respondent. Appellant and respondent. When you go for the appeal. Rosta, what are you doing? Look into my eyes like a bundi. Amna hand Sini. Okay, the ratio normally appears towards the end of a judgment. When you read the judgment fully to the end, then only you will understand what is the rationality is there. And the end of the judgment, but unfortunately, you can't just skip to the end. You cannot make it a skimming. I don't know the reading techniques. Reading techniques also there in your legal methods. And especially it comes to the communication skills for lawyers. The reading techniques. Can you read the newspaper from the first page to last page? No, nobody will read. A man who is retired, okay, perhaps he will read it from first page to last page. Otherwise, every person, there is interesting pages there. Like for you, models, dresses, Rangya Modomo, na hairstyle. There is one page is there. So the people will turn to that page and get. And some people they say they don't read all those things. They read the editorial article. Those who wants to know how he analyzed it, because it is having the gist. Editorial article will write. And the people, those who are interesting, they write the sports page, moisture. And business page, last but one. The front page, political, matters and political things. So you cannot read the entire, but here you cannot skip, because if you skip, no, some rationality will go away. So you have to read the entire thing. You cannot skip it. That is called skipping method. I told you now the skipping method it is. Turn to the directly, you skip the first page because you are not a politician. You go to the model page, and you sportsman, you go to the last page. And I am editorial board, I want to see only the middle page. In the middle page, editorial board is there. Editor will write their own comment there on any particular issue. With analysis, he will write it. With supporting ideas, he will write it. So these are the things, that's why you can say skipping. That is called skipping. So you will skip it, just skip to the end. And it is a bit like watching a mystery show. It is harder to find the answer when you jump in part way through. Suppose if you jump, no, you could not understand the connection. And you will have to read the case in full again, because you skipped in the middle. So don't skip it. Read from the first to last page. But it takes muda kubwa, because a judgment may be consisting of some at least 90 pages, 30 pages, 20 pages, 100 pages. Court of appeal apana, only inne. Only inne out kumi. Sio kumi. Because letters are makuba kubwa. And hence it is that is the RTX test. That the text is different. And that is very big. And the judgment is not that much. Lengthy judgments are there. Otherwise, you have to read that 20 to 30 pages, then only could understand whether the rationality is there or not in deciding the case. So, you cannot say that read the whole case, that is a more important factor. And in its basic format, a judgment start by outlining the facts of the case. First head note. Ju, actually the title of the case law. Then Chini. No. Name of the? No, that is the title. Chini. Title Chini, I am speaking, not Moisho. Did I say Moisho? You never saw the cases, decided cases in the journals, or you will get it in the court of appeal or registry. Here also you can get it the cases. Mohan's registry, you got it. The cases decided with the Mohan's High Court, they will get it. And you check it. Chini, the judge who decided that case, how many members are there, judges? Judges Gina is there, and who is the Chief Justice, or who read the judgment, it is there. And there are also down when you count, dissenting judgments are there. Moshe, last. Assenting judgments, Panza. And the last dissenting judgments means they did not agree. And generally, after the head note, you will find the facts. Of course, head note would be there only in the journals. Of course, sometimes no, it may be there in the cases also. In the cases also, they will give the head note. Otherwise, they will give the facts. Brief facts of the case, undisputed, they will write. The brief case of the fact is undisputed. Then other things will follow, where the question of law comes. So here they say the basic format is the judgment starts by outlining the facts of the case before considering the legal argument present to the court and then making the decision. So there is a sequence is there. I told you PFIRAC and IRAC. Issues are there. What are the issues are framed and how issues are utilized in the application. That is the analysis. And later on that you will see the conclusion, how they have come to the each issue conclusion. So there it says that then making the decision, the ratio would not be the summary of the facts and the beginning, but you do need to read the facts, and the court's decision and how the law applies may rest on the sum of the parties' circumstances. The court's analysis of the legal argument is also essential reading. How the facts are there, how the law is applied, and how the analysis is made. And you have to read the entire thing, although the ratio will probably be located at the end of the legal analysis. You will find that legal analysis later on in the ratio, means the right way of applying the law to the facts. Just before the court makes its finding that the defendant is guilty or the defendant was negligent. Whether the defendant is guilty or the defendant is negligent. For instance, you take the case of the Donegal versus Stevenson, actus novus non intervenes, means there is no break of chain. Break of chain is not there, because from manufacturing till it is open at the consumer in front, there is no break of chain. Means somebody has opened it and sealed it and put the snail inside. No. It is a sealed bottle from the manufacturing unit till it is opened in the pub by the waiters or waiter. Up to that extent, there is no break of chain. And hence, product liability comes. A person who manufactures the drink will come into the picture. Yes, if it is tampered in the middle, they have broken it again, they have sealed it, means there is a possibility that somebody has inserted to defame the company. To defame the company, he might have inserted, but it is a packed bottle. And the people, those who packing there, they will come say, no, it is not broken. They can easily make it out by looking at it, is it broken or not broken, because they are expected to see is broken or not broken. Means seal, I am speaking. So that's why they can make it out. And whether they're guilty or not, their product, the manufacturer is held liable to pay the compensation. Even though the producer will not know who is the consumer. So they say neighborhood principle is there. Who is your neighbor? A person who consumes is a consumer or your neighbor. For neighbor, you have the duty to take care of him. Neighborhood principle. Number one. Number two, that case law says a man should not be a party to the contract. Not necessarily. Privity of contract is not there. Either she may be a consumer, you may be a consumer, I may be a consumer. So, a party who consumes it need not be a party to the contract. That means privity of contract is not applicable in the torts. Privity of contract is not applicable in the torts. That is called privity is fallacy. Fallacy means false in tort. That is the second principle. The third principle, it is the development of the negligence started from the Donegal versus Stevenson. It is the first case law how the negligence is evolved and came in the different shapes. Mostly this negligence only plays an important role. In accident, how the accident will occur? Sir, intentionally, is it? Is it? You make a false judgment. You think that you can cross, you can overtake it, but meanwhile you collide with the other person. A false judgment is the result of the incident. And never cross at the turning. Overtake. You never overtake at the turnings, because we don't know what is coming from the front. Yes, straight is there, yes, you can overtake, because you could see it. So, my point of giving is, a person is defendant or liable or not liable, we'll come to know at that instance only. We read the entire thing, then yes, he would be liable. And the fourth one is focus on the key facts and arguments. To help to find the ratio, when you are reading the judgment, focus your attention on the precedents, means what are the cases decided earlier, and are the legal principles that court discussed at the length, at the facts of the case, and the judgment emphasize. How many cases they referred in that particular case law, having the similar nature of the facts, and a similar judgment is given. So that also be seen. Then the fifth one, the aha moment. The ratio is essentially the reason why the court reached a particular decision. The outcome of the case, therefore depends upon the ratio decidendi. Means, so if you read something that makes you to think, you know which party is going to win or which party is going to lose. You may be in a ratio territory, and going back to the crime, show example, it is a bit like watching a murder mystery and having a hunch as to who is Hood unit, means who is the person that who wants to be a perpetrator. Perhaps that is the meaning of whodunit. I don't think that there is such a word it be there. Whodunit. Would do it, I believe. But when you see the sentence, going back to the crime show example, it is a bit like watching a murder mystery and having hunch, and who is going to win. That is the meaning. Who is going to win? I means the hunch is who is going to be liable. Murder means liability is there, is it not? Murder mystery. And who is the loser? And who is actually the person who did the murder? I don't know. Did you watch sometimes detective movies? In the detective movies and the mystery movies, till end you don't know who is the killer. You don't know who is the killer. In the last you can know that, oh, he is the killer. It's the mystery movies. And suspense movies. Suspense, that is. Nobody knows. And neither you can have you can have an idea to hunch also. Here also they say hunch. Hunch means keeping in view, yes, he is the culprit and he is the perpetrator, he is the murderer. And especially if you see a movie, Alfred Hitchcock, he is the producer. Alfred Hitchcock is a very famous producer, Hollywood. And if you see this movie, in each movie, we cannot expect that he is a murderer. No. Because his movies are in different style. And he never revealed that he is the murderer. In the last moment, he will say that, yes, this fellow is the murderer. Otherwise, you could not have even a hunch also, a thinking, a idea also. So that is they say. And he is having a hunch to do, and what would be the person, and who is the mystery is going to end. Then sixth is dealing with the multiple judgments. If you have got a high court decision where some of the judges have written a separate opinion, and you know that the ratio would not be lurking on the dissenting judgment, instead of look at the ratio in the majority of decision. That's why I told you, in the bench, there would not be any or even number. Even number means divided by 2. It is always the odd numbers. 3, 5, 7, 9, 11. Because Nusu, 11 Nusu will not come. Either comes either 5 or 6. If the 5 is the descending judgment and the 6 is the ascending judgment, which judgment will prevail? Online. I repeat the question. In the bench consisting of 11 members, and the 11 members, 6 members are assenting judgments and 5 members are dissenting judgment, then which judgment will prevail?
Dissenting.
Dissenting judgment prevail. Nimefurai sana bana. It is a dissenting judgment means minor judgment. A minor will not prevail over the major. Law will prevail majority. Is it clear? That means assenting judgment. Assent means consent, agree, assenting judgments. Dissenting means disagree. So, majority is law, and hence, assenting judgment will win. Margaret, do you want to speak anything?
No.
Do you want to speak?
I was saying that of majority will prevail. The same has already been spoken.
Yes, we already decided. The majority judgment will prevail over the minority judgment. Minority judgment is a dissenting judgment, and the majority judgment is a assenting judgment. At that instance, majority will prevail. That means assenting judgment will prevail. Is it clear? Say yes.
Yes, it's clear.
Sir, you are
Yes, sir.
forcing us to say yes. I told majority is the law. Agreed?
Yes.
But not necessarily
Agreed,
true.
sir.
Because majority of thinking is to drink. And the minority say drink is not a good. Better use it for chakula. But these fellow drinkers, the alcoholics say, no, I'm not chakula, kuala kunwa. So, majority will want to drink it and minority want to eat it. Hela madogo, which is the proper way. Sir, I will give the proper way. Neither we can spend the whole amount in the drinking, nor we can spend the whole amount in the chakula. We can make a nusu nusu. Those who wants to eat, let them eat. Those who wants to drink, let them drink. Are you following me? See, we have to harmonize it, not to hurt anybody's feeling. Is it clear? So that is the point we are making it out here. So multiple judgments are there, assenting judgment and dissenting judgment, and the majority is the decision. So, but if the judge wrote a separate decision and who hunt for the ratio probably just not given a trickiest, no. A one man cannot make it out like that. Majority should have to make it out. And the ratio will come at that instance only when the majority comes, but not the minority. So don't panic if you find the ratio. If you find the ratio decidendi over there, don't be panic. You can directly say it's the ratio decidendi case. Or you can say it's the obiter dicta, not applicable as a precedent in the other cases, even though having the same facts. Because here we want to give the justice to the party, hence we are deciding it. But it cannot be used as a precedent. So, don't panic if you find any ratio. Yes, if you find yourself in this situation, look case in your textbook, casebook or lecture studies, the very good chance the ratio decidendi will be explained, if not actually quoted in the case of the summary. Even if you think you are found the ratio, this can be good and to confirm your approach in the working. When you are writing the case brief also, you can write your own opinion. This judgment is not properly decided. You can write your opinion. You can deviate it. Yes, it should be done in this manner. That means you are applying the brain to the facts and the law. And that is the way that you have to deal the case laws. So, my point is now, suppose if anybody has done a rape, let you presume it, by forcefully, and people have taken the picture. In the picture, a person who is raping is smoking a cigarette, and the cigarette, it is the ash, still it is hanging over there. If a person really rapes anybody, the ash will not be there. Am I right? Because any moment ash may fall. If really he is raping a woman, then ash would not be there. Means somebody has taken the picture as that he is raping. So is it not a logic? A ash should not be there. You check it. You move it, ash will fall. Just move it. Don't do anything. Ash will fall. Or ash will be very lengthy. It may fall at any time because of the weight. Are you following me? Sir, we never smoke, sir. That's why we don't know. I say observation. Ash will fall. When the ash is lengthy, it definitely will fall. A rapist, ash is lengthy, definitely should fall. But that means he is not doing the rape because it is fabricated. taking the picture, to annoy the fellow, to make him not to contest for the member of parliament. Are you following me? See, if any person wants to contest for the member of parliament, he should be free from criminal record. Is it clear? I say criminal record, not divorce. Divorce is the criminal record. Not necessarily. Wife could be having the different school of thought and the husband is having the different school of thought. They thought they would compromise, but later on they could not see that they could compromise, and that's only the solution.
Ibariki Africa, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Asante sana na sikiliza mimi darasa online. Mungu akubariki na kukulinda.